especially after the mention of the subject by the Prime Minister himself in one of his rallies. I am joined by none other than Sai Deepak, counsel in the Supreme Court. Sai, many of these issues, a lot of the public looks forward to your opinions on these issues, and I am aware of the fact that many applicants or those who have submitted their submissions to the Law Commission that has invited submissions on the very complex issue of UCC have also sought your opinion. So can I begin by first asking you, what is your overall view of a UCC and this UCC debate or work being re-kick-started by the Law Commission?
So my positions have evolved with time. So perhaps a decade ago or so I was a very strong votary of the UCC. But with greater reading, I've come to the conclusion that it's a slightly complicated situation. My position on some of these Indic issues are well known. So one of the first questions that I've asked myself is, if the government proposes to come out with a UCC, what is it going to do to the already truncated rights of Hindus as a community, which were truncated as a consequence of the unilateral imposition of the Hindu Code Bill between 1955 and 61? So that's one question. Second, see, assume for a moment that if there is a particular issue with a particular group, and if it happens to be a Hindu group, typically the Indian state has shown the guts to come after the Hindu community to say that the state has the right of reform, and they have the constitutionally granted and bestowed rights, so to speak, despite countervailing rights of Hindus as a community to protect their customs. If such is the case, and if the government or the state is interested in addressing certain issues of polygamy and whatnot, or discrimination with respect to women in terms of succession and whatnot, in a particular group, why should the rest of the communities also be saddled with it?
So you're contending that if a fresh UCC or a uniform code comes for all citizens of the country, it will be once again Hindus who will end up making concessions, or will the others be brought up to par with the Hindu community, which is already under a unified code?
See, if this is one of those attempts where some of those groups which are perhaps behind the learning curve on some of these aspects, and they are sought to be brought at par with the rest of us, I would say it's a welcome move. But knowing how the Indian state has operated, where it has never believed in taking a community-specific action, particularly if the community happens to be a non-Hindu community, I typically approach these issues with a greater degree of circumspection, doubt and deep suspicion. That's where I'm coming from. People might say that is this the position of a constitutional lawyer? Well, I can always say that this is the position of a practicing Hindu who also is a lawyer who practices in the Supreme Court. I'm entitled to this position because I've read how the state has typically wielded its power in a very unilateral fashion and in a very partisan fashion.
Disproportionately on the
100%,
Hindu citizen.
Yes.
But I know for a fact that several parties who've made their submissions have contacted you, have sought your opinion, and some of those opinions would have made way to their submissions as well. Can I probe you a little bit more? As far as this exercise by the Law Commission is concerned, what would those submissions from your side be, or suggestions or queries be from your side?
So without violating any privilege issues, of course, broadly what we are looking at is those practices which are particular to a particular mindset, and from the standpoint of succession, from the standpoint of polygamy, that's one, and 3, child marriage. These are the broad issues that we have asked the Law Commission to seriously consider. See, if anybody wants to sell the UCC as one of the biggest endeavors of the fascist Indian state to prosecute a particular minority, it's unfortunate that this conversation revolves around minority persecution, when the same community and its counterparts in the rest of the world seem to have embraced better positions on the same issues. And particularly if, assume for a moment that the Middle East happens to be the epicenter for a particular faith system, and that region has embraced a different position altogether. So to say that this particular subcontinent owes its allegiance to the faith more than the epicenter of the faith itself seems like an ahistoric position to take. It's almost as if a new convert says that he is more religious than the original himself.
But the whole issue of faith in itself is under question, right? Whether in a country like ours, a constitutional secular country, whether we can have faith govern these rules or not. Now, fundamentally, that is the question when it comes to UCC. When does the state intervene to overrule what may be mandated by faith?
So I've seen 2 contrasting positions and extreme positions being taken on the subject. First is to say that personal laws and issues such as marriage are pure civil issues which have nothing to do with faith. And the second is to say that they're entirely governed by faith and therefore they must always be governed by faith. One, In principle, I think it is a flawed argument to make that personal laws have nothing to do with faith. Yes, they do have everything to do with faith.
Yes.
Even within the community, there's huge diversity depending on the sect or the subsect you belong to. Two, so what is the next question? And therefore, there comes the simple question of where do you draw the line between the community's ability to preserve what it believes are its core practices and the state's right to interfere with those core practices with legitimate justification. So typically we apply the proportionality test. First, what is the object sought to be achieved? Is it constitutional in itself? Two, how is it sought to be achieved? And that is a question of what kind of curtailment or abridgment of rights are you looking at? Three, to what extent? This is the triple test or the triad that we typically apply. Unfortunately, none of these questions can be answered yet, because we don't know what this dhancha or this document looks like. I'm not blaming the government for it, because I think it's a catch-22. If you come out with a draft, you'll be accused of formulating a draft behind closed doors without taking the community into confidence.
Yes.
And if you don't come out with a draft, I think it's become everybody's excuse. Oh, where is the draft? What are
How do we know what we're commenting
What are we
about?
talking about, right? So I think perhaps at this stage, we are looking at the initiation of a conversation to understand what the reactions could be. By we, I mean as a person. I don't speak for a party or a government, so I'm not in a position to speak on their behalf. However, I think there needs to be a greater sense of clarity on what is the broad end goal that the dispensation is looking at. To what end are these inputs being sought? Let's look at it this way. If you don't have a proposal in place and you're asking people, aap apni comment de do, what are we exactly commenting on, right? How many myriad diverse suggestions are going to come across, and what are they going to translate to? Usually what happens is, as part of a legislative process, and I had the opportunity to present this document before the Constitution Bench in the same-sex hearing, there's a very detailed, systematic document which the Ministry of Parliamentary Affairs has put out on how do you set the ball rolling on the legislative front. So after the Law Ministry consults, speaks with a few committees, usually a draft is released for public consultation. I would have expected a similar procedure to be adopted in the context of the UCC, where you basically say this is the broad outline. Assume for a moment that you don't even come out with a draft. Perhaps you could identify what are the areas
that UCC will touch upon.
Give some clarity on that. Because I'm not interested in deriving vicarious pleasure that kisi aur ke adhikar kam ho rahe hain. I'm interested in protecting my rights first.
But is it not clear what the UCC will touch and will not touch? Because I know that there is a little bit of a grey area left for speculation right now, and some who may be interested in that for various other reasons are making use of that point.
Correct.
But from what we understand, UCC will govern institution of marriage and all the rights that flow from marriage. So that will include, you know, your adoption, succession for your kids, divorce, alimony, things like that. Is that not the right way to look at it? Is there any confusion over that?
See, it's if I were asked to apply my common sense, I'd certainly agree with you. But the problem is in the realm of public discourse, particularly when you're looking at wide participation from a variety of stakeholders, it shouldn't be left to imagination, is my very clear submission.
There should have been a note on it.
See, let's look at it this way. When you speak of the CAA, even if you don't have a document in place, you know exactly what it's going to address. Why? Because it's looking at providing shelter to people who are persecuted outside. If you speak of an Article 370, the issue was always clear. Rahega ya nahi rahega. UCC is not a one-point agenda. It touches upon at least 4 or 5 issues. So what are the issues and how are those issues sought to be addressed? There's multiple layers there.
And maybe that could have helped before the submissions were sort of, but maybe we'll look forward to something of that note or a body after the submissions have been asked.
Let's hope.
You know, one of the questions that is asked, Sai, by those who may want it, not want it, but just a general question is that why do we need a national UCC? The Supreme Court has recently said each state can look at it. Uttarakhand is one of those states that's almost about to bring in a UCC bill. Why not go that way, then enforce a national UCC? Do you think if we went state-wise, will we achieve the same objective as, let's say, a UCC aims to achieve as per the directive principle itself?
See, if you look at the language of Article 44, it speaks of uniformity of civil code across territories. The onus of ensuring uniformity across territories lies with the central government. I am not therefore saying that some form of cooperative federalism is not possible here, because each state may have its own diversity. So you may want to start with that. So it does fall within the realm of legality to allow states to set the ball rolling. So I'm not on whether they can or cannot do it. I'm asking the larger question of should they be doing it in such a piecemeal fashion? Which means what happens? The pot is kept boiling for how many years when each time a state starts doing this?
And we've got like 28 of them.
28 of them. Demographics of each state are different, and you're looking at a situation where when each time a state starts this, whether it's going to coincide with local elections, will that have a bearing on it? And considering that India is perpetually in an election cycle, this is going to be an issue for years to come. You want to address the issue, do it once for all. I can still understand if this is the strategy adopted by a party or a dispensation which has a fragmented mandate from the public. That's not the case on this issue. So if you think that your core constituency wants it and you enjoy majority, then you must at least show the courage of your conviction and walk the talk here and have an open discussion on the subject.
The government, obviously the central government has kind of made it clear that they are in favor of it, and this has been a long-standing election promise or an electoral promise of the BJP. But on the issue of state, you're saying that, how long will the pot be kept boiling? I get your point, but how about if for example, if one state starts doing it, the other does it, third does it, fourth does it, by that time there is a domino effect. That discussion has already been had, some of the points have already been discussed, some have been seen in implementation. Would that also not lead to people getting more comfortable? Because right now there's a large section that is just extraordinarily uncomfortable with the idea of the UCC. What do you think?
So it's not a bad idea, and I would say that it's not a bad strategy in that particular sense. Then why call for opinions? There is obviously a clear mismatch. On the one hand, you seem to be leaving it to the states. You're delegating it to the states to take a decision depending on their situation. And you're also asking for opinions here. Perhaps the government is trying to, let's say, juggle multiple balls here to see.
Or test the waters.
Test the waters. That's a possibility. Doing it before 2024, I'm still wondering what was the intent behind it, because surely applying the very same common sense that the government expects us to apply to understand what a UCC could be, I don't see this coming before May or April 2024.
But it's to set the ball rolling. They've set their intention clear, and somewhere the ball has to be, somewhere the start has to be made.
So it appears that somebody has a checklist somewhere. Ram Mandir ho gaya, 370 ho gaya, bacha UCC.
Very good. Well, the BJP is very open about it. All right, on the issue of UCC, since I have you, and one of the biggest legal query that has been thrown in multiple debates that I have held, for example, on this issue is that there already exists a Special Marriages Act. Now, whoever wants the protection of a secular law, does not want to be governed by their religious code, already has the protection of the Special Marriages Act, then why do you need a UCC?
See, the argument here is slightly problematic because when this question is raised, it forgets one important assumption, which is the state is expected to take a call with respect to what kinds of marriages and what forms of succession are acceptable and not. If you take a specific position and you're doing so because you believe that somebody's dignity is affected, either as a group or a class or an individual, then leaving it optional doesn't work. So I'll give you a simple example. I think around 2008 to 10, we had this copyright amendment bill, which was meant to give greater collective bargaining power to artists. Why? Because the assumption was artists as a group or as individuals don't have the same bargaining power as the producer, right? And therefore, the law must provide for something that protects them at the outset. To the extent that those protective provisions cannot be waived off through a contract, saying I'm giving up these rights. Even that is not possible. Of course, that's still a legal question. Now, if that applies in the realm of copyrights, shouldn't that apply in the context of individual dignity? Fundamental rights. And you're looking at a situation where somebody has to suffer the indignity of having to share the spouse with somebody else, okay? Or that they are never sure of what are the kinds of rights their children will have. These are the kinds of litigation that populate our courts, particularly when it comes to a particular group.
In any case, some would also make the argument that the Special Marriages Act was kind of a piecemeal provision in itself. It was brought about because maybe successive governments were not confident of codifying some of these laws that have been left uncodified.
No, the purpose of the Special Marriage Act was slightly different, which is to facilitate intercaste marriages and to facilitate interreligious marriages, because each religious marriage, which is under the Hindu law or the Muslim law, they have their own definitions. So those people who are not from that community will not satisfy those definitions unless they convert. So assume that one of the partners doesn't wish to convert, but wants to get married for reasons of love or whatever it may be. Then you cannot do so under the Hindu Marriage Act, you can't do it under the Shariat Act. So therefore a secular option was provided. This in no way addresses the question
of UCC.
UCC.
Exactly. So you've answered my question, and it answers the question of why Special Marriages Act is not sufficient enough to tackle the issues that UCC aims to tackle.
Correct.
The other big question is that, you know, several of these cases, for example, the triple talaq case, it came from the community, women went to the court, and a favorable judgment was given by the Supreme Court. Similarly, for practices like nikah halala, nikah mutta, polygamy, there is litigation that is taking place. Why not let that route satisfy the individual and the citizen and bring about these reforms when the society is ready, instead of, let's say, you know, bringing about a wholesale difference?
See, on the issue of the triple talaq judgment itself, there are serious questions which are now to be answered on whether the judiciary was right to take up the issue. Because in the Sabarimala case, the court has formulated about 9 questions which have been referred to a 9-judge bench on the power of a court, even exercising rights under Article 32 or 226, to enter into the realm of faith. Okay, that's a very serious question. There are 2 questions. One, competence. Second, does the constitution envisage such a thing? Because it's a secular body which is expected to undertake an assessment of an ecclesiastical document, a religious document, which they may not have a training for. As an individual, I may have a training because I have an interest in it. Does it mean that the institution has it?
Sure.
There's a distinction. That's one. 2, therefore, what is the consequence? I may agree with the outcome of the triple talaq judgment, but I may not agree with the body that has the power to do this, which is to say this should have been done by the legislature and not by the judiciary.
But that's why the court left it to the legislature to bring in a law. They just gave a judgment saying that, you know, this practice is unconstitutional.
Correct. See, it's like this. So assume for a moment that you speak of a particular practice and its validity within the meaning of the Shariat Act. Then the judiciary, even if it is ruling only on the question of criminality and legality and constitutionality, it still appears that the legislature is diffident and does not have the confidence to take the decision on its own and wants to cop out by saying, oh, the Supreme Court has said it. What else? I mean, we don't have an option.
But ideally, it shouldn't come from the Supreme Court. This is purely in the domain of the legislature
because
and the
that
executive.
still pampers the sense of exceptionalism and exclusivity that any mindset demands. That unless and until the Supreme Court says that no state, no government has the power to interfere with our beliefs, that cannot be accepted.
You talked about exceptionalism. Of course, Muslim exceptionalism is talked about not just in India, but it is being talked about in various parts of the world now, especially Europe and others as well. It is a reality that we live in. Look at what happened, for example, to CAA, right? I don't want to get into the merits and demerits of it anymore, but it's a reality. Speaking of that, do you feel that something like a UCC can become a reality, and how soon can it become a reality? Because you already must be aware of the reactions that are coming in. There are ultimatums being issued. There are threats being issued that something like this just cannot be done. Our religious laws cannot be touched.
Right. That has been said for decades now. I would say that's been said even before the Khilafat, especially after the Khilafat movement. I'm used to hearing these things in public discourse ever since I have taken an active interest in it. The question is whether Bharat's attitude has changed to these threats and reactions. Whether it remains I don't know. But if the track record is anything to go by, CAA shows us as a soft state. Farm laws, NRC, we don't speak of the NRC anymore. It's been almost shelved in public discourse, right? I genuinely hope that Europe does not have the very same moral authority or the guts to give us these pontificatory lectures anymore, because now they have understood what is exactly at play. And I hope they have learned their lessons. Should they want to come and talk to us, I think Bharat must actually take a leaf out of the European book and say, practice tolerance.
But do you feel India has moved ahead from that kind of polity, that kind of public discourse, where certain issues were either not discussed at all, and if they were discussed, there was either either an omerta surrounding that issue, or the level playing field was not there to ask the same questions of everyone who's a citizen of the country in the same way, in the same form?
Unfortunately, as more things change, the more they remain the same. And the clearest example of that is Section 195 of the amended code that they have come out with, of the IPC. And if you were to read it, see, one thing that we are taught as lawyers is never go by the title of the document, go by the content of the document. So most people seem to be happy with the symbolism. Oh, it's changed to an Indian name or a Sanskritic name, so on and so forth. But what does it say ultimately? Read section 195. And you would see it is perhaps one of the most pernicious gags on free speech in the context of religion, where even legitimate academic criticism on the basis of history with facts backing you can invite penal action. That seems to be the direction in which we are going.
But isn't that already the case?
See, somebody using street power is one thing, but that street power has managed to influence legislative outcome, where the threat of that street power has now got the sanction of the law. That is a deeply problematic issue. And in light of that experience, I am not going to be swayed by any expressions of bravado in public domain. I need to see the document. I need to see what it translates to. Until then, I will remain agnostic, although I'm a Hindu believer.
Yeah, so a lot still needs to be done, and seem to be done, for us to believe that the Indian state cannot be held captured by a certain vote bank.
Correct.
Or by an exceptionalism for a certain community.
Correct.
But coming back to the issue of UCC, several people have also made the argument that it is a directive principle that does not make it binding.
Right.
And there is no need that we can re-evaluate what was written in the Constitution 75 years ago.
Right.
And we can say, okay, जैसा चल रहा है सही चल रहा है, what is the need? Right. And just because it's a directive principle doesn't mean that it has to be done. How would you counter that argument?
The hypocrisy of the basic structure argument comes out in this debate, because secularism is basic structure, directive principles are not basic structure, uniform civil code is not basic structure. So depending on where you sit on the subject, you keep changing the definition of basic structure. That's the problem. Second, of course, directive principles of state policy are not justiciable, which is they are not as enforceable as the fundamental rights. However, that does not mean the state is powerless or does not have the power to rule on a subject which falls on the DPSC. Okay? So from right to education to whatnot, you find quite a few issues which fall under the domain of the DPSC, which are now being legalized. So two things that need to be busted in the public domain in the context of directive principles of state policy is they are not enforceable through a writ petition in a court of law under Article 32, but it does not take away the power of the state to legislate on that subject. DPSC is not a bar on the power of the parliament to legislate on any subject.
No, we understand that, but people are saying that just because it exists as a directive principle does not mean it is in our wisdom to do it.
No, so whether the state has the prerogative to do it is one question, and whether the state is wise in doing so is the second question. The state certainly has the power is the answer to the first question. On the question of wisdom, if not now, I think we will spiral out of control. And if you want the clearest proof of it, that Vikas alone is not enough, well, Europe is a standing example or a falling example.
All right. Let me ask you a final question. You said that your position on the UCC has evolved over the years. I remember it from some of our previous interactions. You were wary of the UCC.
Yes.
Because of the impact it will have on the Hindu community as well, which is as diverse as possibly one of the most diverse religions in the world, and it has its various sects. And I remember you felt that the UCC could kind of uniformalize it or make it plain and take away the rich values and heritage or customs or variety and diversity from the Hindu religion by being enforced in a certain manner.
Right.
Do you believe that this is something that is ultimately desirable even for the Hindu community? What is your opinion today?
See, thanks to Sri Pandit Jawaharlal Nehru, our customs and the diversity of our customs and practices were killed when the Hindu Code Bill was introduced in 4 installments. And the history of the Hindu Code Bill, the Shariat Act and the UCC will tell you that Dr. Ambedkar was certainly in favor of UCC. He was held back by Jawaharlal Nehru.
Yeah.
Okay, so people who want to quote Dr. Ambedkar to protect minority rights and secularism certainly don't want to quote him when it comes to the uniform civil code.
In fact, even at that time, it was largely the Muslim community due to which or because of which the UCC was held back.
Correct. In fact, he responds to them basically saying, and this is the history of the Shariat Act which people don't realize, he points out to them that the Shariat Act comes into existence only in 1937.
Yes.
Until then, from Muslims of Malabar to Muslims of NWFP, they were following Hindu law because they were obviously converts from the Hindu fold, right? So his question was, how does something that has come into existence for barely a decade become sacrosanct and immutable? Please answer this question when you've been following Hindu law for generations together. This was a question. 2, I remain fairly suspicious, or let's use the word circumspect. But the question that I certainly want to ask is, are people going to latch on to my opinion to protect their interests? That would be deeply problematic. Someone shouldn't be saying, oh, he's talking for Hindu interests. Let's use that as an opportunity to say, let's not have a UCC at all.
But people are already doing that. They're asking questions of the impact on the Hindu community.
So my question is, or rather my answer is, we have already suffered. That's done. Now let's have a slightly different approach to this. So one of the things that the Hindu Code Bill did was to uniformalize all Hindu practices under the rubric of those legislations. Can we at least have a very clear Muslim Uniform Civil Code as a starting point before we think of a common Uniform Civil Code? Now the problematic aspect, or rather the answer to the question is, the Shariat Act of 1937 was the Muslim Uniform Civil Code, which was brought because of Mr. Jinnah. So I've said this before, in fact in a public discussion a few days ago, that those who support the Shariat Act of 1937 are in the august company of Muhammad Ali Jinnah. And those who claim that there is indeed an entity called Indian Islam should perhaps ask, why should we stand by this legislation when prior to that we were governed by the laws that applies to Hindus? Therefore, the Shariat Act effectively severed the cultural identity of the converts. And from there, the journey to Pakistan was a decade away. Now, I am not making any statements. They don't teach prophecy in law school. All I can tell you is this, that the existence of a separate set of values which are completely antithetical to the spirit of this particular land means that you create at the very least the seed for, or the ground for, another form of a two-nation theory. That's it.
So from your position at the start of this discussion about how you would want to see that Hindus do not have to concede any more that they have already done, to the fact that we have already conceded and it is still in our interest to have the UCC. Have I got it correct? Still largely in the interest of the country to have the UCC.
My position is, we will make no further concessions. We have already made. So any discussion around this needs to be community specific, not in the name of uniformity where all of us are included. We have done what we are supposed to do in the interest of integration and clarity. Let others contribute their might in the interest of national unity.
All right. On that note, Sai Deepak, thanks a lot for joining me for this discussion, and let's wait and see exactly where it takes us.
Right.
So